I thank you very much for your presentation and also for leaving this paper to us. It's very, very good and will be helpful in days to come. I cannot help by actually coming back to Franz Kafka and Joseph K. This is a completely situation where we all can feel like Joseph K. being accused of something, being accidental Americans for no reason at all, and ending up in this complete turmoil. Now, when you talk about reciprocity, you're talking about bilateral agreements. Well, we have been in a situation in this institution for years now where the Americans simply do not want to dance with us, and it takes two to tango. So we are in a situation where we need to push and to push once more again. I find this completely crazy. And this committee is being approached by these accidental Americans, and we need to find a way forward, that's for sure. That is not for today, but I would like to encourage the Commission now to take the floor on this and give us your view. Do you think that it's normal that European citizens are being treated like this? I'd like to extend the floor to Germano Mirabile. Or did you prefer not to speak?
I was not supposed to speak, but
I can take it.
Well,
maybe as there is a following point raised for the following petition is on the same subject, so there was a presentation which was foreseen by a colleague of FISMA.
You will have the floor on the next item. I was just, inviting you cordially if you would have a spontaneous reaction to Professor. To our professor and what he just said. Maybe a word of appreciation or a question mark or something. But feel free also not to take the floor if that is...
I have just a point of order in the sense that his analysis is based on the general system of intergovernmental agreements between member states and the US. And it makes a distinction between two different types of IGAs. But IGAs are modeled, so they are adapted in the individual relation between a member state and the US. This means that in a number of these agreements, there is a kind of reciprocity. It's not completely excluded. It's not perfectly symmetrical, but there is a kind of reciprocity. This is only a point of order, because if the individual agreements between some member states and the US are analyzed, some safeguards can change because they have been submitted to the national data protection supervisors before being adopted and signed, and there are differences in the reciprocity. So an analysis should be refined in order to arrive to certain conclusions, in my view, but this is my personal viewpoint on the basis of my experience.
Okay, we have also now taken part of your personal view on this very delicate matter. Thank you very much for being so generous. I would like to invite colleagues now to take the floor. If you have any questions that you would like to raise to the professor who has given us his presentation. And if not, let's move on to the next item, which is the oral question and resolution on the adverse effects of the UN Foreign Tax Compliance Act, the FATCA, on EU citizens and in particular accidental Americans. Now we have Commission representatives with us that are willing indeed to take the floor, and I am happy to invite you to do so.
I have a briefing, but before reading my briefing, I would say that FATCA has been revealing a situation that pre-existed, because if you have U.S. citizenship, you are subject to U.S. tax. The fact is that before FATCA, there was no reporting obligation on our financial institutions to provide information to the U.S. tax authorities. So there were a number of citizens that have dual nationality, that live in the Union, that are U.S. citizens, and therefore subject to U.S. tax. I had a former colleague who was now retired in the Commission. She had dual nationality. But of course, her point of attachment with the U.S. was not only the fact of having been born there. She lived and studied and worked in the US, so she was aware about the tax obligation she was subject to in the US. In this particular situation, we are faced with a number of citizens, EU citizens, that happen to be born in the US, and there was on French TV a couple of weeks ago broadcast on this, on the main news, where people were saying, well, I was born in Chicago and lived there 2 weeks, and my family left the US. But now I discover that I'm subject to U.S. tax law because my bank is informed that I was born in the U.S. is under the FATCA obligation. So, as we say in French, nul n'est censé ignorer la loi, but for them it was a bit of a discovery. And it's as Professor Garbarino was saying, is the lax nature of the link with the U.S. territory that came a bit as a shock for those people because they thought they were, let's say, French citizen, Belgian citizen, Danish citizen, whatever. But if you look at the law is what it is. So they don't have much choice. I'm afraid they don't have much choice. They have to report, if they are U.S. citizens, they have to report under U.S. tax law. One way out, and that was discussed at the previous petition committee meeting where a petitioner was in the room, was a possibility to give up on one's U.S. nationality, and that we know as a cost. That was also something that was broadcast on French TV. I mean, some people had to face a cost of legal advice, had to face sanctions because they did not report timely, they didn't send their tax returns to the U.S. authorities in time, so they had to pay some fees for that. And then they had to pay the fee to give up on their U.S. nationality, actually as Boris Johnson did some months or last year perhaps. As a result, this amounts into costs, but there are ways out in that respect. Now, as we, FISMA, are concerned, is much more in relation to the EU legislation on the basic payment account, what we call the Payment Account Directive. And we interrogated member states. We have taken a number of actions since we sat in that committee vis-à-vis the financial industry. We got into contact with the European Banking Federation and other industry associations to gather more information on how many residents in the EU might have difficulties obtaining financial services because they might be subject to FATCA and because they are supposed to provide a tax identification number to their banks. At the same time, I would say we are ill at ease with that whole issue because it is complex, but there are reasons for that. And we're also ill at ease because in the field of tax reporting, fundamentally, with the Directive on Administrative Cooperation, the level of information and the exchange of information we are requesting amongst member states is not very different from what the US are requesting. The issue we have with the US, with the accidental Americans, is that the distance, the de facto distance in their life they have acquired over time with the US. But otherwise, had they been working, let's say, would you be an adult of 40 years old, having been lived in the US for 30 years, you would know about the obligation. It's more for those people who are, as you say, accidental Americans. So beyond asking the financial industry how many cases there were, and we didn't get really probing evidence, we also asked the European Banking Authority to consult their members, that is, national supervisors on the issue, to assess how many consumers have not been able to open or keep a payment account because of FATCA. Because for us it's basically the crux, as far as we are concerned, in our Directorate General. And it emerged from that query that only one national authority so far had received a complaint related to FATCA. And the number was fairly limited. It doesn't mean that for the individuals at stake it's not an issue, but for the time being we have no proof of a systemic effect. We also raised this issue with one of our governmental expert group on retail financial services, and that took place last month, actually, in April. And I asked my colleagues who prepared the briefing, but why don't we have any conclusion about that interrogation? And the reason is that people didn't know. The public authorities didn't know, and at least those experts that were in the room didn't know about the problem. So I agree. I mean, perhaps it's bad faith, but it seems that in a number of jurisdictions, public authorities are not really aware. And that that was a result of our interrogation to the European Banking Authority. So there, let's say it's between closed walls. I think they would have been outspoken if we had known about it, and we had only one occurrence of an issue. So what we can take as a commitment, if you want, as a Commission, as far as we are concerned, is that with regard to the Payment Account Directive, we are ready to launch infringement procedures. If it appeared that the right to a basic payment account, which is foreseen by the directive, would be denied to either real American citizens, that is, the expatriate, the US expatriate, or the accidental Americans, where they would be in a position to present a tax identification number. So they would be of good faith and they would say, I don't mind paying my taxes until I renounce to my citizenship, probably, or perhaps if they so wish. But so the banks, what we don't want to see is a situation where the banks, in order to avoid an administrative burden, that is the FATCA reporting, would deny access to financial services and in this case to a basic payment account for those accidental Americans. So we would remain vigilant. We have a number of steps that will be taken. I mean, that is only next year, but we won't wait until next year to adjust our actions. As soon as we will get information about complaints, though complaints have to be addressed in the first instance at national level by national authorities. If it appeared to us that national authorities were failing on the enforcement of the Payment Account Directive, then we stand ready to act. That's as far as our Directorate General is concerned. I mean, I might take the floor also from the colleagues on data protection, unless they want to take it. Yeah. On data protection, I mean, the first thing we should say is that we're grateful for the committee of the Secretariat to the committee for having shared with us the report of Professor Garbarino, but we got the report yesterday, so we need to go through it. We need to read it and to see, when we will read it carefully, and to see what the findings are and whether that requires subsequent actions from our side. But already at this juncture, data protection authorities, national data protection authorities, have had to look at the matter. And they fairly recently, actually in February this year, they concluded in a letter they sent to the grouping of European accidental Americans, if I may say, that they, and I quote, that there had been no occasions where the processing and transfer under the FATCA regime had to be prohibited. So if you want, there is a constellation of public authorities' views, be it from the data protection angle or from the tax angle, that seems to converge to say that as far as principles are concerned, there is not much we can challenge at our level. And then I would only recall, as Germano did in reaction to the presentation of a study by Professor Garbarino, that indeed what is underpinning FATCA are intergovernmental agreements, bilateral agreements, and I should recall that the Commission had offered its good services to negotiate a multilateral agreement with the US, and that member states politely declined that offer. And we doubt that we would be ready to reconsider that. Our offer is open, it's still standing, but we have had no signs that they would be ready to reconsider or renegotiate their intergovernmental agreements. Now, at the same time, referring back to that broadcast in France, the conclusion of the broadcast was to say that the French grouping of accidental Americans was undertaking action against the French authority, against the French government, in front of the Conseil d'État, to challenge the intergovernmental agreement. And I'm afraid that might be the way forward. It might require national action before we can do much. As we are concerned, as far as the Payment Account Directive is concerned, we are ready to act if we are provided evidence. of non-compliance. Thank you.
Thank you very much. Very good that you shared this information to colleagues. But I can assure you that to us it's been an issue on the petitions raised, but also by a number of individual accidental Americans calling to our offices repeatedly. It's really an issue that should be solved. So in that context, I am happy that coordinators took a decision to table an oral question, not only to the Commission, but also to Council, which is very, very, very good and timely, so that we hopefully in days to come can see that there is an interinstitutional approach to this. We need also to work together in order to achieve a resilient system that actually exempts those persons that actually are European citizens and just happen to be born on the 4th of July one year or another. I guess also there would be some Europeans that would have liked to be born on the 4th of July in the US for other reasons, but that's a different story. Now, coming back to this issue today, I think that we have sorted, you have given us a lot of very valuable information, and what we need to do now is just for members to endorse the text in the oral question and the resolution. And I would like to open the floor to you on that, if you have something to say, or we can just proceed to the vote. But I would like to state also that the deadline for amendments on the draft resolution has been postponed until Wednesday, 23rd of May at 3 o'clock. So you still have some time to reflect on that. Now, I don't see anybody wishing to take the floor. Can we proceed to the vote on the oral question? Can we endorse the text? Hands up if you're in favor of the text. Excellent. I see everybody unanimously. Excellent. That's what we do. Thank you very much. And thanks to all of you having participated in this. Especially many thanks to you, Professor Garbarino, for your valuable contributions. Don't be surprised if we call you to have your help also in the future on these issues. Absolutely, please do.
I don't want to react to the very sensible points made by the Commission. I react very quickly. Yes, of course, you have to check on a case-by-case basis each agreement, whether these it is reciprocal or not. So we need some empirical analysis. But there is a trend to modify reciprocity in unilaterality by the United States, generally speaking. The other point that was made is that, of course, the accidental Americans are hit, but also dual resident American and EU, because the United States is the only country taxing about risk, and it's widely believed that this is an outreach. So generally speaking, the United States should align with best practices also in this area and tax residents. Of course, if a resident of the United States is cheating the United States, it's justified for the United States to ask information from the banks if certain requirements are met. Last but not least, I would like to emphasize for the committee that by studying this topic and starting from the accidental American, I see that there are relevant issues and questions in terms of data protection. Because from the very beginning, in terms of automatic exchange of information, I had a concern about automatic exchange of personal data, even if they are tax data. So this is a major issue, and the regulation is brand new, but I think that soon we will have, you will, and we as citizens have to address these issues. And that's all. So, only 3 points.
Only in a very few days to come, that will be the new reality.
Yes.
So thank you again very, very much. And let's leave this topic as for now and take it into consideration next time which will be after, let's see. It will be on the 19th of July. that we will vote the resolution text and the amendments.